Добрый день.
Good afternoon, dear colleagues and dear attendees of the panel session of the Dissertation Board. I declare the panel session for the defense of the thesis by Sergey Pokrovskiy. I declare it open. The topic is liability of persons controlling the debtor for bringing to bankruptcy. The thesis is submitted in conformity with the requirements for the academic degree of the candidate of science and law. The specialization is 120003. I would like to remind you to switch off your mobile phones. Let me remind you that the panel session is broadcast on the official website of St. Petersburg State University. It is being interpreted into English. Traditionally, at the beginning of the panel session, I have to specify that under the federal law on amending Article 4 of the Federal Law on Science and State Scientific and Technical Policy, St. Petersburg State University and Moscow State Universities are entitled to confer academic degrees. The degrees are conferred at St. Petersburg State University and Moscow State University is only possible within the scientific specializations and branches of sciences specified by the Russian Ministry of Science and Education. The corresponding order on granting academic degrees at St. Petersburg State University was issued on the 1st of September 2016, order number 6821/1. According to item 17 of section 3 of the regulation on the Dissertation Board for the defense of candidate and doctoral dissertations in St. Petersburg State University is valid, providing 2/3 of the appointed board members are present. The total number is not to be fewer than 4 people. The Dissertation Board consists of 5 people, including 1 foreign board member. He is attending the defense remotely via Skype. Therefore, we have a quorum. We have to establish the agenda for the panel session of the Dissertation Board. The panel discussion cannot exceed 2 hours. The first item, the chairman's presentation about the documents submitted by the candidate for the degree and their conformity with the requirements. Number 2, the candidate's presentation providing an overview and findings of the research, no more than 15 minutes. Questions to the candidate, no more than 2 minutes for each question. The candidate's replies. Number 4, reports on the thesis. The board members will be taking the floor in turns in order to give a detailed account of their opinions and suggestions and questions to the candidate. No more than 10 minutes per person. Item 5. The candidate's comments about the reports on the thesis, no more than 15 minutes. Item 6. Questions from the audience. The floor will be given to the non-board attendees. No more than 5 minutes. It is necessary to fill in the registration form. It's here on the first table. Item 7. The candidates' comments about the talks given by non-members of the board, no more than 5 minutes. Item 8, presentation of the candidate's thesis supervisor, no more than 3 minutes. Item 9, a 5-minute break before the open balloting on conferring or non-conferring the academic degree. Item 10, open balloting, vote counting and recording the results in the protocol. And the last item, number 11, it's the candidate's closing speech. No more than 2 minutes. I would like to start with my presentation about the documents submitted by the candidate and about the board members. The thesis by Sergey Pokrovskiy, Liability of Persons Controlling the Debtor for Bringing to Bankruptcy, was submitted in conformity with the requirements for the academic degree of the candidate of science and law. The specialization is 120003. It was approved for the defense by the order of the Academic Secretary of St. Petersburg State University, number 7074/1, as of the 26th of June 2017. The Dissertation Board was set up by the order of the Academic Secretary of St. Petersburg State University, number 6949/1, as of the 21st of June 2017. The board members are Oleg Gorodov, Chairman of the Dissertation Board, Olga Makarova, Doctor of Law, Dmitry Petrov, Doctor of Law, the board member, Alexander Marchanov, Doctor of Law, board member, Makhmat Rahimov, Doctor of Law, Professor, Director of the National Center of Legislation under the President of the Republic of Tajikistan. He is attending the panel session via Skype. The candidate has submitted the following documents to the Center of Expertise, several documents: an application, report of the supervisor, list of published works, thesis in Russian and English, expert report on the thesis, employment confirmation letter, confirmation of the future publication. The above-mentioned documents comply with item 12 of section 3 of the order on granting academic degrees at St. Petersburg State University. This is the general information I have to make public before I give the floor to the candidate. Mr. Pokrovskiy, welcome.
Dear members of the board, dear attendees, the choice of the topic for the dissertation is as follows. First of all, the institution of liability for persons controlling the debtor has no deep legal traditions, and it is still being formed on the one hand, and on the other hand, I can say that I have scientific and professional interests because I am a judge presiding over bankruptcy cases. The institution of bringing to bankruptcy is quite young in our civil law, and it has no counterparts in foreign laws, except for several CIS countries. And it was too early to say that the formation of this institute has been completed or that there is a balance of interests of the agents. And a vivid example of this is the latest amendment to the law on bankruptcy, which took place in 2017. One of the propositions in this law was repealed, and Chapter 3.2 was added to the law. The need for theoretical interpretation of the changes in the legal regulation of subsidiary liability for bringing to bankruptcy and underlying legal elements, the relation of this institution with other types of civil liability arising in connection with the impact on the legal entity and foreign doctrines, the identification of the problems related to law enforcement and the justification of recommendations for the law enforcement made this research relevant. And the main research findings of this thesis are as follows. Emergence of property liability for the obligations of an independent party if this party is declared bankrupt dates back to the modern period of the Institute of Insolvency. And because of the complication of economic ties and the involvement of legal entities, the retrospective analysis of the evolution of this issue shows the convergence of liability for bringing to bankruptcy with other types of liability arising in connection with activities and management of a legal entity. On the one hand, this allows us to use assumptions and principles from the corporate law. On the other hand, the different public relations and different other problems make it necessary to differentiate special elements for this wrong. And this wrong must protect the property rights of the insolvent legal entity and also make a demarcation line with other liabilities which are connected with the impact on the legal entity. The institution in question is ineffective because there is no clarity and there are no legal traditions in this area. There is no consistency and changes in legal regulations. This is, among other things, is caused by negligence to pre-revolutionary traditions. And there are no objects that allow us to have balance of interests among the agents involved in the process. These participants, on the one hand, have the right to use property and conduct business activities, and on the other hand, these participants have the relations of credit. Insolvency is one of the major risks, and if it occurs, the economic agents resort to the use of the legal entity. They try to be covered by the legal entity. Therefore, the transfer of liability, subsidiary liability, can pose a threat to the legal entity on the whole, which was seen in practice when we saw the amendments to the law on bankruptcy. Here I mean the Federal Law 73. Liability of executive bodies and the liabilities of the participants are based on other fundamentals, and usually they are liable to the legal entity for the negative impact on their property, and their liability is limited by the damages caused to the legal entity. From this point of view, the subsidiary aspect of liability is not in line with the status and basic fundamentals of the liabilities of its addressees. When we speak about the structure of subsidiary liability, I must say that liability of the person causing the bankruptcy is part of relations major debtor, major debtor. The dependence of subsidiary liability on the consequences of the wrong and the depersonalization in bankruptcy proceedings to specific creditors make the subsidiary liability quite vague. Therefore, the construct of subsidiary liability for bringing to bankruptcy did not comply with the subsidiary liability which is stated in the civil code. I think that the instrument of subsidiary liability allowed us to connect with the incitement of the insolvency case. During the reform of the institution of liability, the dependency and subordination of this institution became weaker, and the functional link was made stronger. The incitement of the insolvency case was still a prerequisite for holding the person liable. However, it was not sufficient. What was more important was the property damage caused to the creditors, and now it played a major role to qualify this as a wrong. As a result, a single construct made two layers. One layer was connected with the fact of bringing to bankruptcy itself, and the other layer dealt with the damage, with the amount of damage and the amount of liability. The implementation of subsidiary liability depends on the activities of the proceedings of the person who is held liable. If the person who is held liable is passive, then we speak about subsidiary liability. Otherwise, we see tort liability. The grounds for subsidiary liability is the elements of the civil wrong. And the object here is the relations of credit and also the property of the insolvent debtor. If we prevent the access of the creditors to the property and from the exercising of their rights, then we regard it as a wrong. We also must speak about the absence of reasonableness in the activities of such agents. And the criterion of wrong will allow us to make a borderline here. We should make a borderline between the concepts of insolvency and bankruptcy. Insolvency is an economic phenomenon, and bankruptcy is connected with wrong. The elements of this wrong is characterized by a special subject, the person controlling the debtor. And we can see this in the law on bankruptcy. However, the regulation in this area does not seem to be accurate. and the formation of the attributes of the wrongdoer do not comply with the legal regulation. Therefore, I think we should change this concept. The reform of the law on bankruptcy led to the complex civil wrong, which consists of two contents, bringing to bankruptcy itself and causing property damage to the creditors. Taking into account the features of this institution, I think we should leave only what is connected with damage to the property rights of the creditors. The formation and the description of the subjective part of the wrong must allow us to make a borderline between the insolvency, which is the result of actions in market economy, and the wrongdoing of the legal entity. Public relations of insolvency are characterized by divergent interests. The relations of credit and business activities. The legal construct of a legal entity may lead to different controversies. Therefore, it is quite difficult to provide legal regulations. And we need deep theoretical research into this area. I believe that the institution within the current legislation must provide for the balance of interests of the major participants in the field in question, and we must also provide protection of public relations of different types. And some propositions stated in the thesis have been reflected in the legislation. For example, Federal Law 263 has been changed. First of all, bringing to bankruptcy is no longer a ground for subsidiary liability, and insolvency of the business entity as a damage caused is no longer efficient. And we change the notion of the person controlling the debtor. Besides, some items have been clarified in the law on bankruptcy. For example, the wrongdoer must have some formal functions, and now the person controlling the debtor has less salience in the law. The liabilities of a legal entity and other participants are more important. Article 61.21 now says that it is possible to fulfill subsidiary liability in any other than monetary form. And we see that this is now a different criterion in the law. Item 11 of the law on bankruptcy also says that people controlling the bankruptcy must, as soon as they see the insolvency signs, act in the interest of the creditor and prevent any damage to the debtor. Thank you. Now, members of the board, have you got any questions on the report? There are no questions. You may take your seat. Now we are going to the next item on the agenda. Now, reports on the thesis. We have received reports from all the members of the dissertation board, and there are no external reports. So we'll start with Alexandrovich. So we are going to study different types of liability that arise when we compare it with the doctrine of piercing of corporate liability. Therefore, we see that the objectives and the aims comply with each other. The main objectives of the dissertation are connected with the theoretical interpretation of the concept of subsidiary liability of persons who bring to bankruptcy. And we also must use civil liability, which is connected with the insolvency of the economic agent. So the objects and the aims of the dissertation comply with the structure of the dissertation, which allows the author to aim to achieve all the objectives and aims, starting from genesis and revolution and the evolution of the insolvency and up to the modern regulation. The methods do not contain any controversies, and they are in line with the objectives and aims of the thesis, and they are based on a set of theoretical and special methods as well as methods of cognition. The thesis is written on a high methodological and theoretical level. It is well structured. All the research findings are clarified and well argumented. The thesis consists of 7 paragraphs, also, and a reference list that was used for the research. I would like to speak about some merits. In the introduction, we see the relevance of the research topic, its theoretical and practical significance, as well as the scientific novelty. The structure of the thesis is quite well structured. It allows us to give a comprehensive view of the subject matter. In the first chapter, General Description of Civil Liability for Bankruptcy, the author solved a number of debatable questions connected with the historical and legal study of legal regulation of civil liability of persons controlling the debtor for bringing to bankruptcy. He analyzed types of liability arising from controlling over a legal entity, and the author also describes a general characteristic of subsidiary liability of people controlling the debtor. I agree with the author that in common law and in Roman law there is a tendency not to qualify the cases of simple withdrawal of the assets or disposal of the company's property without taking into account its ability to meet its obligation as a ground for piercing the corporate veil. The second chapter, Liability for Bringing to Bankruptcy through the Prism of Elements of Civil Wrong. The author analyzes the elements of the civil wrong bringing to bankruptcy. The author claims that his result is as follows. If we see that the model should be different from the model which is connected with the tort model. The results and main findings of the research are presented in the form of 4 propositions to be defended, which are well grounded and have scientific credibility. The high level of the research and the validity is proved by the fact that the main research findings were published in 5 academic papers. However, this thesis has some proposition and statements that are open for discussion. First, The work is full of footnotes and references to literature. Sometimes such footnotes take up to half a page. Here I give the pages. And sometimes these references to other works and definitions does not allow the author's view to stand out. And sometimes it's difficult to understand whether we are reading the quotation or the author's view. Number 2, fifth proposition to be defended does not have any scientific novelty since it has a descriptive character. The conduct of the property right of the creditors of the insolvent debtor. What is the practical and theoretical significance of this proposition? I don't think that we should include this proposition in the main research finding. Number 3, as a general critical remark, I would like to say the following. There are 130 items on the reference list, and only one item dates back to 2015, 8 items date back to 2014, and we do not see any items dating back to 16 and 17. However, these critical remarks concern only with some propositions which are not clear or need further clarification, and then do not change the high value of the thesis. So, the thesis of Sergey Pokrovskiy is a research work which allows us to work out theoretical propositions which have social and economic significance. So, I can say that the thesis was written independently. It is coherent and consistent, and also has new research findings as well as propositions to be defended, which proves his personal contribution to the law. The thesis of Pokrovskiy Sergey complies with the major requirements set forth in order on granting academic degrees at St. Petersburg State University, and the candidate for the degree can be awarded the academic degree of the candidate of law specialization 120033. Thank you. I would like to say that all the reports on the thesis, as is required by the appropriate regulation, are placed on the official website of St. Petersburg State University. So I believe that the positive part of the thesis of the report can be shortened, since it is possible to read the reports on the website. Now I give the floor to Dmitry Petrov. I have studied the thesis of Sergey Pokrovskiy, and this thesis is relevant. And besides, all the research findings comply with the requirements for similar research papers. And we see that the novelty is reflected in the dissertation. However, I would like to ask 2 questions. And I hope that Sergey Pokrovskiy will answer these questions. First question. In the first proposition to be defended, the author speaks about the subsidiary liability, and he speaks about the liability arising from causing damage. And the second proposition deals with the following fact. He says that we should abandon subsidiary liability for tort liability, which arises from the contrast of the above-mentioned contracts. And I think this is doubtful, because the author ignores the fact that subsidiary liability has a specific status. And besides, we need special conditions to be able to contrast these two aspects. Here, I think the author should extend his arguments. And the second question. The author says that the wrongfulness of bringing to bankruptcy includes hindering or complicating of exercising their property rights by the creditors, or exceeding of standard risk, or conducting business activities devoid of reasonable social and economic grounds, including insolvency or insufficiency of the property. The author says that this wrong can be committed in the form of an action or in the form of omission to act. However, if we take the reasonableness as the criterion within the standard risk, should we qualify their failure to take measures to restore the solvency regarded as an omission to act? Does it matter that the assets of the above-mentioned persons have these assets, and should we punish in order to provide if we fail to provide assistance? For example, if we speak about the bankruptcy of Vim Avia, we know that the general director of this company did not stop selling his tickets to passengers, although he knew that the company would not be able to do his business activities. So here we see a mission to act from the part of the general director. It's one form of a mission to act. And another example. Take, for example, Bank Открытие. This bank got assistance from the central bank. There, one of the board members knew that the bank was almost bankrupt, and he knew that he might damage the creditors. Still, he said that the bank was bankrupt. When he was asked if he was going to transfer his personal activities to compensate for the damages and for the losses of the creditors. And he said that he wouldn't. Here we also see a mission to act. In the first case we saw a mission to act, but in the second case we see a mission to act when it is possible to mitigate the negative consequences of the bankruptcy. So please clarify these forms of a mission to act when we speak about bringing to bankruptcy of a debtor. The second question is not a critical remark. It's a question for future research. I'm just interested in the opinion of the candidate. But I would like to say that the thesis is independent, and it is a valuable research work which allows us to solve scientific issues important for the law. The thesis comply with the major requirements set forth in the appropriate order on granting academic degrees in St. Petersburg State University, and Mr. Pokrovskiy can be awarded the academic degree of the candidate of law specialization 120033. Thank you for your report.
Mr. Chairman, dear attendees, In my report, I specified the relevance of the Thesis. I would like to focus on the two items. First of all, it's the necessity to provide scientific and theoretical grounds to the concept of liability for bringing to bankruptcy. Here I mean interpretation of the essence of this concept of bankruptcy. Secondly, it's the necessity to provide scientific and theoretical grounds to the concept of liability of persons controlling the debtor for bringing to bankruptcy, considering the criteria of persons controlling the debtor as well as the specifics of bringing such persons to subsidiary liability. All the aims of the study that Mr. Pokrovskiy has said have been successfully achieved. It's an independent research. It's logical and coherent. It has new research findings, which speaks about the personal contribution of the author in the development of the legal science. In my report, I speak about the novelty, the relevance, and the accuracy of the research findings. Now I would like to focus on a number of debatable issues and questions. In the first chapter, the author regards aspects of civil liability, analyzes the liability of those persons acting on behalf of the legal entity as liability of heads or executive officers, and it arises and implemented within the legal entity and insolvency of the latter, and it's not necessary condition for it. It was interesting to read these remarks about the liability of heads and executive officers and the liability of those persons controlling the debtor in case of bringing to bankruptcy. It's a very wise conclusion. On page 205, let me cite, a retrospective analysis of the evolution of the phenomena under research is the domestic civil law and demonstrates the convergence of liability bringing to bankruptcy with the types of liability arising in connection with the use in circulation and the management of legal entity. On the one hand, this makes it possible to apply the principles and concepts formed in a corporate law. In this respect, the question arises, which aspects and principles are meant here? Secondly, is that possible to speak about the unification of the concept of the controlling person, considering that this concept now exists in corporate law as well? Is there any specifics here in the legislation on insolvency? Research finding 1 requires additional explanation. Mr. Pokrovskiy mentioned that in his presentation. Let me cite, the implementation of subsidiary or delictual obligation constructions that have common grounds and concerned persons depends on the procedural activity of the obligated person, the person controlling the debtor. Doesn't imply possible choice between delictual and subsidiary liability. I also think that finding 2 requires additional explanation. This finding proposes to abandon the subsidiary liability in favor of the delictual one. Well, actually, Mr. Petrov mentioned that in his report. In general, I consider this studies to be a independent graded research work, which offers, which solves issues relevant to the legislation on bankruptcy. The thesis of Sergey Pokrovskiy complies with the major requirements set forth in the order on granted academic degree at Pittsburgh State University. Mr. Pokrovskiy can be awarded the academic degree of the candidate of law, specialization 120003. Thank you very much. Now the floor is given to one more board member, Professor Mahmad Rahim Zada. Thank you. Dear Mr. Chairman, members of the Dissertation Board, can you hear me? Can you hear me all right? Yes, we can hear you. It is worth noting that the necessity to define the place and role of the Institute of Subsidiary Liability of persons controlling the debt of bringing to bankruptcy in the doctrine of civil law has not been defined yet. This type of liability is analogous to foreign doctrine of piercing the corporate veil. The thesis focuses on the basic principles of legal entity and brought forward with the type of liability. These all factors define its novelty. I have to specify that dissertation made by the author that the work that he has done is theoretically valuable. He has showed a creative approach. It poses interesting questions and provides answers to them. Mr. Pokrovskiy provides several ideas to improve the current legislation, Russian legislation on bankruptcy. The dissertation produced a very favorable impression. However, I would like to specify several controversial points. First of all, it's debatable the idea suggested by the candidate to abandon subsidiary liability of persons controlling the debtor for bringing to bankruptcy in favor of the delictual one. In dissertation, this idea is given to identify the Russian concept of civil legislation of bringing to bankruptcy with the foreign doctrine of piercing the corporate veil. However, in foreign systems of justice, the use of this doctrine, the law enforcement agents are really careful when bringing this liability in fear of destroying the construct of a legal entity. In this case, the controlling person uses their property as their own. So in this case, the damage is caused to the rights of the creditor. So the creditor is then given a right to make the person controlled debtor liable of a delictual character. In the Russian institution of subsidiary liability and the institution of bringing to bankruptcy, the controlling person does not make use of the property of the insolvent debtor. He has his own subjective rights. When the debtor is insolvent, the controlling person and creditors fulfill their property rights, first of all, at the expense of the debtor's property, or then at the expense of the controlling persons. Subsidiary as the candidate rightly says, the grounds for the liability of the controlling person with reference to Clause 4, Article 10 of the law on bankruptcy is the causing damage to property rights of the creditor. The candidate defines this category of damage as the negative change in the amount of value of property of the insolvent debtor in absence of the equivalent decrease in these obligations or the increase in the amount of claims on its property that is not adequate to the amount of the consideration. I suppose that the thesis would be more logically coherent if it focused also on the liability of persons controlling the debtors directly before the debtor for the damage which was caused while bringing to bankruptcy. Through the satisfaction of claims on the performance of monetary obligations. Another debatable point is about the formation of the construct of liability of persons controlling the debtor for causing damage to property rights of creditors when bringing the latter to bankruptcy. The thesis states that the primary role in solving this task is given to the guilt of the persons controlling the debtor. The wrongdoing of the liable party here is not in the intent to decrease the encumbrance or devaluate the property of the debtor, but in the realization that this act damages or causes harm to property rights of the debtor. As part of the civil law transaction, controlling person have to act without any intent to cause damage to other participants of the civil legal arrangement. In this respect, fulfilling the events aimed at corporate recovery of the insolvent debtor, the controlling person has to conduct sanation in compliance with principles and criteria of fairness and reasonableness. When delivering bankruptcy, at the stage of sanation and examination, controlling persons to reinstate solvency of the debtor, financial recovery plan has to be developed. This plan is developed considering the current economic situation of the debtor and conditions of the civil law transaction. In this view, if bankruptcy takes place, and it takes place as a result of inadequate recovery plan, then this has to be regarded as negligence. The dissertation is rich in content. Its content is sufficient to fulfill the aims and objectives of the aims and goals set by the author. With this in mind, I believe that the thesis by Sergey Pokrovskiy is an independent graduate research work. It's coherent and well-structured, which can be qualified as a work which complies with the requirements set forth in the order on granting academic degrees at St. Petersburg State University, and its author can be awarded the academic degree of the candidate of law, specialization civil law, business law, family law, private international law. Thank you for your attention. Thank you.
Now, I give a positive value to the thesis by Sergey Pokrovskiy. I speak about the relevance of the thesis and the fact that the theoretical research in this area is also quite necessary. And as any thesis, which is an independent and creative work, this thesis has some drawbacks. And I emphasize the following drawbacks. So, one of the statements should be clarified further. The elements of the civil wrong can be grouped into four categories: a person, an object, a subjective side, and an adjective side. This approach gives a legal an equal status to the offense and to the civil wrong. So it may lead to further difficulties when we try to make a borderline between a wrong and an offense. And my second question is as follows. So I think we need further clarification for the research finding, which is as follows. Wrongdoings of bringing to bankruptcy include conducting business operations devoid of any reasonable social and economic grounds. I think that the reasonableness should not be taken into account when we assess whether some activity is wrong or not. So I can say that these drawbacks are specific in nature and they do not change the positive evaluation of the thesis. So the thesis of Sergey Pokrovskiy is a research work, and it provides solutions for scientific issues relevant for the law, and also provides new insights into the law which is relevant for the economy of the Russian Federation. The thesis complies with the requirements of the appropriate regulation, and the author can be awarded the academic degree of the candidate of law, specialization 120033, civil law, business law, family law, private international law. So we have read out all the reports on the thesis. Now I would like to give the floor to Sergey Pokrovskiy so that he can answer the questions. Please remind you that you cannot exceed the time of 15 minutes. Please try to be short. I'll try to organize my reply according to the internal logic. So the first remark, which we heard in several reports. So some people say that they doubt whether we should abandon subsidiary liability for tort liability. In my opinion, we do not contrast subsidiary liability and tort liability. However, we emphasize that they coexist at the same time. And this regulation is necessary, so we must clarify the regulation in this area, which includes liability for bringing to bankruptcy. Therefore, we should take the subsidiary liability in case of insolvency, or we decide that we should investigate the real damage. So the compensatory nature of civil liability shows that these liabilities have a tort nature, and therefore we should take the tort liability as the major construct. As for the choice for a particular construct, this choice presupposes that we need a subject which takes a decision. When we speak about subsidiary liability, neither court nor the person who is held liable nor the person who initiated the case have any choice. The choice of the construct is determined automatically. And the person who is held liable shows our direction. if the person who is held liable has a passive position and we cannot prove the damage, then we see subsidiary liability. If the person who is held liable has an active position, then we must qualify him as bankrupt and decide whether we see any damage to the property rights of the creditors. And the final decision regarding the damage to the property rights and the amount is predetermined by the amount of the liability. As for the property rights of the creditors, I would like to say the following. The property rights of the creditors are not clearly defined in the law. So the law does not state what property rights of the creditors must be protected in the bankruptcy law. So in my thesis, I studied the issues connected with the liability towards the creditors of executive bodies of legal entities in relation to foreign law. Foreign scholars say, as well as my personal experience proves this, I can say that creditors might have various interests. There are different categories, and they can be grouped into 3 categories. Ground for having relations with the debtor, freedom to leave these relations, and information about the financial position of the debtor. Therefore, we cannot prescribe equal status to banks that have information about the financial position of the debtor or the tort creditor. So we cannot give equal status to these creditors. Besides, there's also a group of creditors, a specific group of creditors which try to have advantages by any means possible. All creditors of the insolvent debtor act independently and they try to have their needs satisfied. And if the debtor is qualified as insolvent and the bankruptcy proceedings start, then the creditors are put together in one litigation case. And after that, the creditors are arranged according to their priorities. So their needs must be satisfied according to the order stipulated by the law on bankruptcy. Therefore, we can say that creditors have the rights that must be protected. And from this point of view, we must assess if their rights have been violated by the persons controlling the debtor. And therefore, we have formulated the concept of the property rights of creditors. So the persons controlling the debtor may include different participants, both the executive bodies and those who determine the conduct of the debtor. We see that there is a convergence of different types of liability. In my thesis, I emphasize that the foreign doctrine of piercing into corporate veil is a counterpart of bringing to bankruptcy in terms of the object of the wrongdoer. If we speak about bringing to bankruptcy, then we mean the relations of credit. However, the doctrine of piercing into corporate veil uses the legal entity in the civil activities. Now, I would like to comment on the report of Professor Makarova. She speaks about the unification of the concept, the person controlling the debtor. I was planning to speak about the unification in one of the research findings, because in this case we will have more clarity in the civil law. In public law and in civil law we use different criteria and different concepts, and this devoids the legislation of clarity. So the clarifications that have been made to the law include some other criteria, and we should also unify the above-mentioned concepts. Bringing to bankruptcy is a wrongdoing in the business area. Therefore, we must separate insolvency, which is an everyday phenomena, and insolvency becomes common if we come across some crisis. So we must make a borderline between a criminal phenomenon and an economic phenomenon. Therefore, in my thesis, I write about the following thing. I speak about the elements of the civil wrong. The elements of the civil wrong is part of a bigger category. I mean, a bigger theoretical category. Therefore, I made the following suggestion. The elements of bringing to bankruptcy can include 4 elements of a wrong, and during my research I was able to identify these 4 groups. And also my research shows that bringing to bankruptcy which is connected with subsidiary liability in civil legislation is very similar to the bankruptcy from public law. There we see that there is a borderline between the offense and the wrong, and it is stipulated by the appropriate legislation. Therefore, it is easy to identify the 4 types of the wrongdoing. Now, how we can speak about wrongdoing using such concept as reasonableness. Here I can say that the activities of different participants in the proceedings, including the management of the company, is stated in the law, which uses this concept reasonableness. Therefore, it was inevitable for me to use the concept of reasonableness. In my thesis, the reasonableness is not related to the assessment of an action itself. It is related to the reasonable ground. And here I would like to speak about the rule of a business decision. According to this rule, the agent has the right to file a claim against the director that caused damage to the legal entity. And one of the grounds and one of the things that the person should prove is the evidence that the decision was not reasonable. He must prove that a reasonable person cannot make such a decision. And if this is proved, then we see the beginning of a litigation process. In this litigation, the director is regarded as somebody who acted the way he acted, and he must prove that his actions were reasonable and effective. When we speak about the Supreme Court and the Higher Arbitration Court or the Constitutional Court, I would like to say the following. The control from the court is not acceptable, and we see that the proper legislation states these as well, and it is consistent with the rule of the business decision. In order to assess the activities of the executive bodies, such criterion as good faith is used, and it allows us to define whether the actions were efficient. So, on the other hand, it allows us to find out that the decision was not reasonable or was not effective. Now, I would like to say a few words about the omission to act of the persons controlling the debtor. When we see that the debtor is insolvent, sometimes in case of where business activities continued and the management must capitalize on the gains. I would like to draw your attention to the following fact. Liability that is implemented in bankruptcy proceeding can be divided into three aspects. First, for violating the appropriate legislation, for failure to file a case, and liability for bringing to bankruptcy. In my thesis, I must say that only the last aspect is the research topic of my thesis. Besides, in bankruptcy cases, we see different cases which can be in consistency with the public law. Therefore, we see that the executive bodies also have some liability in this area. I would like to answer some of the questions. If we do not meet the requirement and continue our business activities, is part of subsidiary liability for failure to take the matter to court, and this is not covered by the research topic. As for the omission to act of the executive body when they have the possibility to provide assistance, financial assistance to the legal entity in order to maintain solvency of this legal entity. In this case, the status of the executive body does not mean that the executive body must capitalize the society. The participants and the founders have these obligations. The executive body must make the insolvency known to the other beneficiaries of the legal entity and also take specific measures in order to maintain solvency. So, the director refused to provide assistance, and this is not a wrong. As for the conduct of the participants or founders, it is regulated by the law on legislation, Articles 31 and 33, if I'm not mistaken, which deals with financial assistance. According to this law, the possibility to provide financial assistance using personal assets to an insolvent company is recommended, but it is not obligatory. Therefore, we cannot say that this was a mission to act on the part of the general director. However, such people must have in mind that a mission to act in order to restore solvency leads to bankruptcy and, as a result, leads to subsidiary liability for bringing to bankruptcy. Therefore, in order to avoid this liability, I think it would be reasonable for the participant or for the founder to take measures using different types of assistance, including his own assets, in order to restore solvency of the legal entity. Here I would like to refer to the court rulings of the German court, which does not regard such omissions to act as something which is detrimental to the property of the legal entity. I think I have answered all the major questions posed. Thank you very much. Please take a seat.
So, I would like to refer to the attendees. Is there anyone who would like to take a floor to ask questions? To ask for some clarifications? So I see there is no one who would like to take the floor right now. So the floor is given to the research scientific supervisor of the candidate, Mr. Papandopoulou. 3 minutes only. Mr. Chairman, members of the Dissertation Board, my report is positive and has been submitted to the relevant department. So the study, the Thesis, complies with all the major requirements. So I still have a couple of minutes. So I would like to say that the topic that Pokrovskiy has chosen is a controversial issue, and it was especially controversial when we had Article 10, which was getting bigger and bigger in size. But now we have 12 items instead of 10, and there we see that it's thoroughly developed now. I mean, the issue of bringing to bankruptcy. In my opinion, it's not that I want to state my opinion here. Well, yes, I'd like to somehow support my student, but in chapter 3, some of the ideas discussed in the Thesis by Pokrovskiy are really reflected there. This relationship between the the relations between the creditor and the debtor can really be complicated by the presence of the persons controlling the debtor. So how can we regard these cases with persons controlling the debtor? We can't avoid the debtor. We can't avoid this relationship of the bankruptcy, the relationship between the creditor and the debtor. Otherwise, we enter in the general construct of civil law, where with these differences between different types of enterprises and so on. So, in my view, we have to consider this aspect and keep it in mind. Let me remind you that Mr. Pokrovskiy has taken his own viewpoint, and his viewpoint is shared by many other scholars. So I kindly ask the members of the Dissertation Board to confer their degree. Thank you, Mr. Papandopoulos. So according to our agenda, we have a 5-minute break. Please switch off the broadcast.
Так, значит, следующее действие заключается вот в чем. Я ставлю вопрос.
So I put to the vote the issue of conferring the academic degree. Let me remind you that this is an open individual voting. I would like Professor Rahim Dazada to start. Are you for? I'm for. Mr. Molchanov, for. Mr. Petrov, for. Mrs. Makarova, for conferring the degree. So, according to the open individual voting, Mr. Pokrovskiy is conformed an academic degree of Candidate of Science in Law. Now, for the closing speech, I give the floor to the candidate, as it goes in our agenda. In my closing speech, I found it really appropriate to give the words of thankfulness to my scientific supervisor for guiding me on this scientific path, and to thank the members of the Dissertation Board for their serious position and for their attention to my study, for their positive reports and reviews. I promise I will go on. I'll continue research work, considering we have this really positive beginning. So we have fulfilled our agenda. I declare the panel session of the Dissertation Board closed. Thank you very much for attending.
وای شاه مشاهد چیگور جنبست کن رحمت کلام